Well, hello. Did you guys see what posted? It's so amazing. And just like I said in comments, I absolutely swear Ellen loves us back. She loves us just as much as we love her. She gave us the most beautiful gift she could give us on Vanzan Sham Day. It's officially Vanzan Sham Day now. And happy Vanzan Sham Day to everybody. Yeah, I'm really nervous about this being in Lyman's hands, to be honest. We'll see how fast he moves on it. There's also an emergency deposition something or other filed by Blake. I didn't even bother to read that because when I saw this, I was like, is this what I think it is? Is this what I think it is? And it is. So what we have tonight is called, let me put it on the screen, is called a motion for judgment on the pleadings. So I don't know if you know what that means. This is somewhere in between a motion to dismiss and a motion for summary judgment. But it is definitely a motion that could end everything. So the difference between this, without getting into super detail, between this and a motion for summary judgment, this is just on the pleadings themselves. Summary judgment is on the pleadings and all of the evidence, all of the depositions, all of the discovery, and it's not yet time for a motion for summary judgment. This comes first, and this is just asking the judge to look at her pleadings and to say whether or not there's a case, basically. And then, so what it does is it spells out to the court all of the reasons that they feel that she does not have a case. So we see, I haven't gotten through the whole thing at all because I got so excited. I'm like, I'm just going to go live and do this right now because I'm up and it's middle of the night. And so that means I'll probably be up for a lot longer. And that means I'm going to probably sleep until at least noon. And then I'll be so late. So I wanted to just jump on. This isn't my deep dive style where I've researched everything. We're just going to get through the actual document. Nikki asked, do you think he will grant it, or do you think he will find an issue? If I read him correctly, he's going to find an issue. I don't want to get too hopeful that he's not going to do that because he's kind of shown us that that's what he does. So, yeah, I don't want to get too hopeful, but at the same time, these are, judging by the document we went over yesterday, that already had quite a few of the one about the 47.1. Was that yesterday? I'm losing track of days. Anyway, it kind of, we have a repeat of some of those arguments, and I don't know how he's going to counteract these arguments, but yes, like Hens just said, he always finds an issue. He'll say Ellen didn't file with her shoes tied or in a green jumpsuit. Exactly. And well, here's the thing. If he's going to deny it, he's going to deny it instantly. So, that's the thing about him. Who knows? I don't know. I don't know how he's going to argue this legally to deny it. But the good news is that even if he does deny it, we are very, very close to summary judgment timeframes. And him denying this does not mean that they cannot also file for summary judgment, which is really, really not that far away. So, yeah, let's go ahead and just jump in. I'm going to get past all the pages of her beautiful table of authorities. This woman knows her case law. That's for absolute certain. And I just love her for it. So the introduction, she just kind of starts out telling the story and what she based her claims on, how she pled them. And one of the things, and I had talked about this just, was it this month or last month when I talked about the dismal outlook for the rest of Blake's claims? And I went through like her FIHA and I'm like, she can't claim that here. That's not going to go. And the labor code, same with that. And I kind of went through like what her claims are and how badly they're going to fail. And it's so funny because this is what Ellen's basically telling the judge, only in a much more detailed and better I mean, just a beautifully written thing, something I could never do. But anyway, let me see where she starts. All right, yeah, let me just go ahead and start with the bullet points. So here's where she starts. Fija. You're supposed to be writing papers for your psychology class, and here we are. Yeah. I've already been to bed and like tried to sleep and like forget this, and I got back up and I started working on something else. And then I thought, let me check one more time, and I found this. So here we all are up when we should all be sleeping. I think most of us, maybe not all of us. But so fija does not have extraterritorial application, and thus plaintiff's fija claims, and that's the third, fourth, sixth, and seventh causes of action, should be dismissed with prejudice. So I think you all know by now, with prejudice means that dismissed and cannot bring them back to the court again. It's like, that's it, you're done. Thank you, Mrs. Busted Can of Biscuits. I love your name. I needed this, was bursting. I think we all needed this. I was all keyed up and this was like the perfect Vanzan Day present. I know she loves us. I know she knows we're going to celebrate this and just pick this date to make us all ecstatically happy. So bless you, Ellen. But or maybe she's just celebrating Vanzan Day. Who knows? But this is the best gift we could have gotten on this day. So absolutely all our love to Ellen at this moment. So that knocks out quite a few causes of action right there. As predicted, you can't file these in New York. It just doesn't even make sense. Then the second point is a big one too. Lively fails to allege an adverse employment action, a requisite for retaliation claims under FIHA, and this is very important, Title VII. Title VII is the federal rule that she came under, the federal law that she came under. And of all of them, I think I had said when I talked about the last of her claims that these are the ones that could be survivable because they are federal. But she has a very good point here, a requisite for retaliation. And a lot of us have worried about retaliation because retaliation is much easier to prove than defamation. It has a lot lower bar. But as she states here, that a requisite for retaliation is an adverse employment action. So what is that? This is a serious employment problem. This isn't like my feelings got hurt, I was uncomfortable. This is a serious, it involves things like termination or firing, demotion, pay cut, denial of a promotion, a suspension, your hours get cut, you get transferred to a worse position or a worse location. It's negative performance reviews. It's denial of opportunities or some serious kinds of harassment. But it's not just a little minor discomfort. It's a big thing. And nothing happened to her. She didn't get a pay cut. She got her full pay. She got way more pay than anybody else did on that movie. She got everything she wanted. So there really were no adverse employment claims that she could make because nothing bad happened to her on that. So she's saying this, okay, we knocked out all of those. Now we can knock out the federal too because there was no adverse employment action. The third point is that she fails to plead a causal link between her complaints of harassment and the alleged smear campaign as required for retaliation claims under FEHA and Title VII. And this is one of the things that I had mentioned before too, when I talked about the last of her claims. It has to have occurred well within a specific time period to say this was caused by that. So she claimed that the retaliation was because she had filed a complaint about harassment. But she claimed that the complaint was back in May of 2023. And then there was no retaliation until she alleged that there was one in August of 2024. So we're talking well over a year. And there's no standard that says it has to be within this time period. But what you can do, and what I had done, was I looked up cases where it was denied and cases where it was approved. And for it to be approved, where it was like within like 4 months. But anything close to a year or over a year was denied, because it has to have temporal proximity. It has to have happened so close together that you can say this was a direct result of that. So over a year, forget it. That's ridiculous. So that knocks down that complaint. So the next point is she fails to allege that she exhausted her administrative remedies against It Ends With Us movie, a predicate for any FEHA claim against the movie. So this is something we haven't gotten to see all of the discovery yet, but she has. Ellen's seen it all. So if there were complaints found, she knows it. If there weren't complaints found, she knows it. Any kind of remedy that Blake supposedly tried to do, she would have had to have handed over by now. So they've seen everything. They've deposed almost everybody. So she can say this with certainty, whether or not Blake actually did this. Joel of Creative Tennis, thank you so much. This judge is going to deny this motion so fast. I'm afraid he will. So I'm going to enjoy this tonight while I still can. You know what? I wouldn't be at all surprised if this man denied it on a Sunday. I mean, I really could see him doing it on a Saturday or Sunday. I really could, but we'll see. We'll see. The next one, Lively's defamation claims are banned, and these are the 12th and the 14th causes of action by California's litigation privilege or New York's fair report privilege, whichever law applies. So I think we talked about that yesterday, that what is this? Defamation claims. All right, I'm going to skip that because I can't remember exactly what I was going to say about that. So I might go through later and like really break this down. And Perez's names are savage. They Jesse says that's why Perez calls her baseless. Blake and Gavin says Perez's names are savage. Yes, I love his unliftable Lively. Okay, and the last one is Lively fails to plead a civil conspiracy, specifically a tort that all defendants were capable of committing. So she basically takes the last of Blake's her causes of action and says, no, none of these can survive. And now we're going to get into the detailed reasons of why she says this. So her claim arises from the claim that she was mistreated on the set of the film during the first phase of production, then unlawfully retaliated against for reporting harassment that occurred on the set. Through her company, Blakel, she entered into an actor's loan-out agreement with It Ends With Us for Lively's acting services. And then we have some redacted information About that actors agreement. So we haven't gotten to see that yet, but that's something I think we all wanted to see because there was a big question about whether she ever signed and when she ever signed an actual contract. So I don't know if this actors agreement is an official contract or if it's that secondary thing that they claimed was that they said was possible to go ahead and proceed with filming, even though it wasn't an actual contract that she signed. I'm not quite sure, but we still don't get to find out here because that part's redacted. The film was shot in New Jersey and New York, where Lively resides. Lively first complained about inappropriate behavior in May 2023. On May 26, Lively told Sony that she wanted to file an HR complaint. Production was suspended in mid-June 2023 due to strikes by the Writers Guild and Screen Actors Guild. During that time, Lively experienced invasive, unwelcome, unprofessional, and sexually inappropriate behavior. The Second Amendment complaint details the alleged incidents of inappropriate behavior on the set in paragraphs 85 through 109. Before returning to production on November 9th, Lively presented a list of 17 protections for return to production as a condition of her return to complete the film. The 17-point list was intended by Lively to remedy the misconduct that Miss Lively and others had reported earlier that year. Now, it's important to notice Ellen is admitting nothing here. All of this is in quotes. This is just taken directly from Blake's claims. So this is not Ellen saying that any of this is true. These are just the allegations directly lifted off of Blake's papers. And I also want to call to mind, because a lot of people get mixed up about this 17-point, and they combine it with that no more document and claim that Justin signed this thing, therefore he admitted that he had done those things. The 17-point was just demands for production to continue. There was no actual accusation. There was no anything like that. And it was signed by Jamey, not Justin. So people get that mixed up all the time. And I want to clear that up, that I don't think anybody here confuses that. That's mostly people who support Blake. But this 17-point list was about having an intimacy coordinator. It was about having a Sony rep. And there were no admissions to anything on that. And it was signed by Jamey, not by Justin. Okay. The Wayfarer parties agreed to Lively's terms. And remember, when they agreed, they said, well, basically, we were doing all of these anyway. So that's why it wasn't a big deal to sign. So the parties executed a contractual rider incorporating those terms into the unsigned May 2023 Actors Agreement. Wayfarer was not a signatory to the November 2023 rider, which was signed by It Ends With Us management only. Notice back then it was still unsigned, so she made that clear for us right there. On January 4th, 2024, the parties participated in an all-hands meeting in New York, where, according to Lively, a plan was approved for implementation of certain protections that will be adhered to for the physical and emotional safety of Miss Lively, her employees, and all cast and crew moving forward. Production resumed on January 5th, 2024, and concluded on February the 9th, also 2024. Neither the second amended complaint nor its forerunners identify any active harassment that occurred in the second phase of filming, that was January 5th to February 9th. In fact, on January 14th, 2024, Lively assured a cast member that the inappropriate behavior had been stopped and that it's a professional set and we're getting good work. That's a nice little tidbit there. On the eve of the film's premiere and release, rumors of discord on the set already swirling in the press. Accordingly, on July 31st, 2024, the Wayfarer parties contacted a crisis communications specialist to diffuse the negative publicity and protect his reputation as the film's director. On August 2nd, 2024, the crisis management team circulated a scenario planning document with a proposed strategy, and this was the caveat to it, should Lively and her team make her grievances public. So this was all, it was not proactive. It was like reactive. We're going to do this. We're having this ready just in case. If she does that, then we'll implement these things. Lively contends that this was the launch of a smear campaign, and that in the weeks and months that followed, the Wayfarer parties engaged in a sophisticated, coordinated, and well-financed retaliation plan. According to Lively, the defendants mounted a well-funded retaliation campaign that sought to bury and destroy anyone that challenged Mr. Baldoni's brand. Based on these allegations, Lively asserts claims of sexual harassment and retaliation under California and federal law, breach of contract, civil conspiracy, defamation per se, and false light. Okay, now she gets into the standard for judgment on the pleadings. I love this stuff. I really love this stuff. Because a lot of people, when we're not attorneys and we hear accusations, we're like, oh, goodness. Oh, it did happen. But what we might think something is based on the legal understanding of what it is could be something very, very far apart. So, according to the rules, Rule 12.6 permits a party to move for judgment on the pleadings after the pleadings are closed. And this is this motion that she's done now. But early enough not to delay trial. So pleadings are closed. She filed her second amended complaint. That's the last possible pleading that could be made. And so that's why the time is now to do this. It's too soon for summary judgment because there are still depositions being taken and still discovery being collected in the form of documents and electronic files. Let's see. The standard for Rule 12 for a Rule 12C motion is the same as that for a Rule 12B6. That's the motion to dismiss for failure to state a claim. So it's a lower bar, but let's see. Thus, judgment on the pleadings is appropriate where, with all reasonable inferences drawn in favor of the non-moving party, the non-moving party has failed to allege facts that would give rise to a plausible claim or defense. A complaint must offer more than labels and conclusions, a formulaic recitation of the elements of a cause of action, or naked assertion devoid of further factual enhancement in order to survive dismissal. So there has to be some substance. It can't just be a list of whiny complaints. The plausibility requirement calls for enough fact to raise a reasonable expectation that discovery will reveal evidence supporting the claim. A claim has facial plausibility where the plaintiff pleads factual content sufficient for the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Although a court considering a Rule 12.6 motion is generally limited to the contents of the complaint, the court may consider the complaint, the answer, any written documents attached to them, and any matter of which the court can take judicial notice for the background of the case. Also, a complaint is deemed to include materials incorporated in it by reference and documents that, although not incorporated by reference, are integral to the complaint. So that means not just her second amended complaint by itself, but anything, any exhibits or things related to it. The judge can consider those things with it, but in this case, not the depositions, not the gathered discovery. Okay. Now she gets back into the California statutes. They have no extraterritorial application. That means they cannot be applied outside of California. And none of Blake's allegations occurred in California. Therefore, they are considered extraterritorial. They are outside the territory of California. Plaintiff asserts claims for harassment, retaliation, failure to supervise, and aiding and abetting under California Government Code 12940, FEHA. Retaliation under California Labor Code 1102.5, and sexual harassment under California Civil Code 51.9. The threshold question is whether FEHA or the other cited California statutes have extraterritorial application, whereas here, the plaintiff is not a California resident and the discriminatory conduct did not occur in California. And then she cites some case law where the FEHA and California labor codes were dismissed because it was a non-California resident who failed to establish a nexus or connection between the allegedly wrongful conduct and California. And we saw in the document about 47.1, she made this argument so very well that there's no plausible connection between her claims and California. And she tried to say, well, because Wayfarer is a California company, but we saw in her last filing that that doesn't cut it. We saw case law where it was refused. Okay. Krista has a good comment here. Shouldn't the Vanzan lawsuit subpoena fall under criminal law? Wayfarer should have been attacking this more bold and determined. Well, Wayfarer was collecting evidence, and still, I mean, they haven't deposed. They have the deposition for Vanzan on September 30th. So they're getting all of, you have to have evidence first. You have to make sure you have everything before you can do that. I really, really hope that Jennifer Abel files a criminal complaint. I truly, truly hope she does. But any criticisms against Wayfarer about this, I feel like they're unfair because you have to have proof. You can't just, if you come to court with these kind of complaints and you don't have enough evidence, you're just going to get dismissed again. So they're not ignoring it. They're not dragging their feet. They're not anything. It's just they're collecting what they need right now to proceed. Okay. FEHA does not protect non-California residents such as Lively, where the allegedly discriminatory conduct occurs outside California. California recognizes a presumption that the California legislator did not intend a statute to be operative with respect to occurrences outside the state, unless such intention is clearly expressed or reasonably to be inferred from the language of the act or from its purpose, subject matter, or history. When a statute gives no clear indication of an extraterritorial application, it has none. And this Ward versus United Airlines, this was one that was in the last. I think a lot of these are from the last one because they're really good cases that really, really prove it. So I'm going to skip some of those because it's just case law, just repeating situations where it was determined already in a court of law that these did not apply. And she's done a very thorough job with providing those here. So it will make it really, really hard for the judge to decide otherwise because this is what all the judges have decided already. The employer or employer's residency is not sufficient to overcome the presumption that FEHA does not apply when the tortious conduct is outside California. And then here's the case law for that. Again, this was mentioned in the 47.1 too, because it was one of Blake's claims that she had a right to apply these because Wayfarer is Californian. And she's like, here's a whole case, just a whole load of case law that says you're wrong. To apply California law, the complaint must establish a substantial connection between the situs of the legally relevant conduct to California. Thank you again. Is that a Ajal of Created Tennis? I hope I said that right. The Elsrich video on this is going to be wild tomorrow. Oh, yeah. And thanks for your awesome coverage on the case. Oh, thank you. Oh, I can't wait. I love Elsrich. She is hilarious. We needed her. I love how there's so many different types of creators that comment on this case because we can just get a good variety, a good mix of it. When you feel like laughing, when you want to know all the details, or when you want a quick, brief rundown of stuff, you always have a place to go. I just absolutely love it. Okay. Lively is a New York resident. The alleged acts of sexual harassment occurred during the first phase of production on the New Jersey set and in New York. Thus, the allegedly hostile work environment, which the core of the alleged wrongful conduct was not in California, but in New York and New Jersey. The second amended complaint lacks specific averments of any participation in or ratification of the harassment conducted by Wayfarer or It Ends With Us in California. All right, so I'm going to go ahead and skip because this is long. It's 32 pages. And the rest of this, we've already talked about this with the 47.1 document. And this is just, she's being as absolutely thorough as she possibly can be. No doubt, because we're dealing with Lyman. But there's no need for us to go through every single case law that proves that we get it. We're not as dense as Blake. We know this didn't happen in New York or in California and does not apply under California law. So I'll skip to the next point. That the Title VII, those are the federal, and the FEHA, another type of California, claims against It Ends With Us fail because plaintiff does not plead that she exhausted her administrative remedies. Assuming FEHA applies extraterritorial, it doesn't. California government code requires that an employee, such as plaintiff, exhaust her administrative remedies before filing a civil action alleging FEHA violations. Similarly, to assert a claim under Title VII, a plaintiff may bring a suit in federal court only if she has filed a timely complaint and obtained a right to sue letter. This was a question we had because when she filed her CRD, she did get a right to sue letter from them. But it said on that letter that it was not good to file a federal lawsuit, that if you wanted to file a federal lawsuit, you had to get a right to sue letter from the EEOC. Now, the EEOC does not put things out publicly. So if she did, we wouldn't know. If she didn't, we wouldn't know because there's no way to look up any kind of complaint from them. But Ellen would know that. Exhaustion. Wait, let me see. Did I? Plaintiff has the burden to plead timely exhaustion of administrative remedies, such as filing a sufficient complaint with the California Civil Rights Department and obtaining a right to sue letter. Under the FEHA, exhaustion of administrative remedies is a jurisdictional prerequisite to resort to the court. Therefore, failure to file an administrative charge before commencing suit is ground for dismissal of an action for violation of the FEHA. Similarly, under Title VII, failure to exhaust administrative remedies is grounds for dismissal. On December 20th, 2024, Lively filed complaint with the California Civil Rights Department against Wayfarer and 10 other defendants and received a right to sue letter for the named parties. Lively's employer and party to Lively's actor agreement and rider is not identified in Lively's CRD complaint. And as a result, Lively did not obtain a right to sue letter. Did you guys see that? This is new information. She didn't name her employer, and so the right to sue letter she got, am I reading this correctly? Lively did not obtain a right to sue letter with respect to It Ends With Us. Accordingly, It Ends With Us is entitled to dismissal of Lively's 3rd, 4th, 6th, and 7th causes of action. Okay, so It Ends With Us is one of the many defendants. Remember, there's Justin, Jamey individually, and then there's Wayfarer, and then there's It Ends With Us, and then there's Melissa Nathan and her company, and Jennifer Abel, on down the list. But this is particular to the movie itself. So she didn't name the movie itself. So, she doesn't have a right to sue them. In addition, as more than 300 days have elapsed since the allegedly unlawful employment practice, It Ends With Us is entitled to dismissal with prejudice of Lively's first and second causes of action. Oh boy, it's too late. It passed the statute of limitations. You didn't name it. It's too late to name it now. So got to let that one go. Section 6, the complaint fails to state retaliation claims under FEHA or Title VII. So Title VII was the only one I was worried about because it's federal, but it looks like those are all failing too. I'm going to take a sip real quick. Hold on. Absolutely. Absolutely. He'll be up at 7 to deny. He can't have the news reporting on this. Lyman's going to be furious, trying to find a way to deny in to deny in part and grant in part. Absolutely. His favorite. And then you got to search and search and search to find the little bitty bit he granted. Title VII provides that it shall be unlawful employment practice for an employer to discriminate against any of his employees or applicants for employment, because he has opposed any practice made an unlawful employment practice by the subchapter. To establish a prima facie case of retaliation under Title VII, a plaintiff must show, 1, she engaged in a protected activity. So that's like reporting the incident, filing a complaint. That's the protected activity. 2, the employer was aware of the activity. Did the employer know she reported it? 3, the employer took a materially adverse employment action against her. So that means she would have had to have reported it. The employer would have had to have known about it. And then the employer would have had to have done something bad to her, like cut her pay or cut her hours or fired her or something like that. And then 4, a causal connection between the alleged adverse employment action and the protected activity. If you get fired 5 years later, there's no causal connection. If you get fired a year later, but if something bad happens to you, if your next review, your reviews have always been good and your next review is like a month later and it's bad all of a sudden, that's causal. Okay, so those are the standards. California Government Code 12940H, FEHA, similarly provides that it is unlawful for an employer to discharge, expel, or otherwise discriminate against any person for complaining of sexual harassment or other discriminatory conduct in the workplace. Retaliation claims under Title VII are broader than under FEHA because FEHA requires an adverse action for purposes of employment opportunity or any materially adverse change to the terms of her employment. So there has to be some change in her employment and it has to be for the worse. The Second amended complaint includes only 3 cursory references to adverse employment action, each alleging a coordinated campaign to cast Miss Lively in a false light during the publicity and promotion of the film and thereafter. So in her entire Second amended complaint, in all of that word salad, there are only 3 references to an adverse employment action, and all of them relate to August of 2024 when they are out there promoting the movie. And she's getting all of the criticism because now people have seen it and they have a lot to say about it. So these are the only references. That's, like I said, the complaint, she says she made a complaint in May of 2023. So we're over, what's that, a year and 3 months later? A year and 3 months later. And those are all the complaints, all 3 of them. Okay. So, Lively's claim of an adverse employment action is based solely on the publication of negative publicity commencing in August 2024, after production ended and after discord on the set spilled into the public eye. And this was all who's doing? What did Brian Friedman say about she has to look no further than a mirror? She was the one dropping breadcrumbs. She was the one saying, after sitting in the editing booth alone with this man, all of a sudden she couldn't bear to share the red carpet with him. She could sit all alone in a, who knows the size of an editing booth, just the two of them. That was fine. But she couldn't be seen in any promotions with him. Does that make sense? And couldn't say his name anymore, even though we saw her still texting him during the time they're talking about edits and she's asking for the dailies and all that stuff. But now all of a sudden she can't even hear his name. Well, when you do stuff like that, people notice it. And she did it because she wanted it to be noticed. And now she's going to act like, oh, no. Why are people talking bad about me? Okay. Let's see. No adverse employment action where plaintiff was no longer an employee, worked at a different job, and defendants lacked control over any aspect of plaintiff's working conditions. Filming was over. When did they say? February 9th or something like that? So she was no longer his employee. What working conditions is she talking about? She kept him away from her. She wasn't working with him. She was no longer under him as an actress under a director. So this is just nonsense. Now we have probably some juicy stuff here under this redacted bit, because this talks about her CRD complaint, acknowledging that her complaints would constitute something we don't get to know at this moment in time. This court should decline plaintiff's invitation to create what? I want to know. By creating a new standard for adverse employment actions. Plaintiff's failure to allege an adverse employment action alone defeats plaintiff's ability to establish a prima facie Title VII or FEHA violation sufficient to survive a motion to dismiss. This is pretty juicy, where there's a lot of stuff we're not getting to see. I think you're right, Cold Fairy. That's what I deducted from it. The redacted parts is probably that they're moving to create a new notion of what an adverse action by an employer could be. They want to rewrite everything. It's all that authorship. Part B, the Second Amendment complaint fails to plausibly plead a causal link between the protected activity and the alleged smear campaign. Merely pleading an adverse employment action is not enough, and a plaintiff must plausibly allege that the retaliation was a but-for cause of the employer's adverse action. What does that mean? But-for causation does not require proof that retaliation was the only cause of the employer's action, but only that the adverse action would not have occurred in the absence of the retaliatory motive. Lively alleges protected activity, complaints of sexual harassment, and a public relations campaign which commenced in early August 2024 at or about the time of the film's August 6th premiere. The complaint, however, does not link the two, much less plead that the public relations campaign would not have occurred absent a retaliatory motive. Simply put, Lively fails to plead causation. So in order to show there's a link, you have to say, this wouldn't have happened if I hadn't engaged in this protected activity. So this wouldn't have happened to me in August if I hadn't filed a complaint. last year in May. But the stuff being said about Blake in August of 2024 was stuff that people were organically saying that they didn't like about the movie and about the way she was promoting it. So it would have happened whether she filed a complaint or not. A causal link may be shown by pleading the employer's knowledge that the employee engaged in protected activities and the proximity and time between the protected action and the retaliatory employment decision. A retaliatory purpose can be shown directly or indirectly by timing, where the protected activity was followed closely in time by adverse employment action. Yeah, Blakey is a total victim. In the next one, plaintiff fails to show the requisite temporal proximity between Lively's complaints and the allegedly retaliatory smear campaign. Over a year passed between plaintiff's May 2023 complaints and the August 2024 launch of defendant's alleged smear campaign. So she alleges the smear campaign was launched. Okay, no, this is a different case. In this case, this smear campaign was launched more than 4 months after the plaintiff engaged a lawyer and more than 3 months after he resigned. And in this case, this is what I was talking about. If you look at case law, which ones were granted, which ones were denied, it has so much to do with how close together these things happened. This one was more than 3 months after he resigned and more than 4 months after he engaged a lawyer. And this case in the Southern District of New York said, that's not sufficient. That's too far apart. That's not close enough. They found that while courts may infer such a link where the alleged retaliation occurred shortly after a plaintiff engaged in a protected activity, this time lapse exceeds the limit. So 4 months was insufficient in this case. And now we're talking about a year and 3 months. There's another one in the Second Circuit dismissing retaliation claim on summary judgment where there was a 3-month lapse between the protected activity and the alleged retaliation. Add a year to that. So this was Southern District, another one in the Southern District of New York. In the Second Circuit, a gap of more than several months is typically too long by itself to survive summary judgment. I had some of these when I went through my episode about the dismal future of her. I don't know if it's the same cases, but I always try to find ones in New York, especially in the Southern District. So I might have found some of these same ones that she's finding, but that's what I reported back then, that it's too far apart. The temporal proximity between the plaintiff's protected activity and the alleged adverse employment action, somewhere between 3 and 6 months, is insufficient standing alone to establish a causal connection. While the Second Circuit has not drawn a bright line to define the outer limits beyond which a temporal relationship is too attenuated to establish a causal relationship, the weight of authority supports the view that 10 or 12 months is too long. This one sounds familiar. This might be one of the same ones that I found. I'll have to go look back again because I searched specifically in the Southern District. More than 9 months, too remote to establish. 1 year is far beyond what courts in the circuit have determined as temporally close. 10 months between alleged protected activity and adverse employment action represented a lack of temporal proximity. She has really posted tons and tons of case law here. Neighbors of Lyman, some of these might even be his cases. 6 months insufficient. I mean, what's he going to say? What's he going to say to this? Lively surfaced her grievances in May 2023, and the alleged smear campaign began in August 2024, 15 months later. Even assuming that the January 4th, 2024 all-hands meeting, where Lively renewed her complaints, is the starting point, there's a 7-month temporal gap between her complaints and the commencement of the so-called smear campaign in August 2024. Thus, the alleged retaliation is too remote to establish a causal link. The lack of temporal proximity refutes any possible inference that the smear campaign was motivated by a retaliatory purpose. To the contrary, as set forth below, the crisis management public relations campaign designed to counter the already negative and escalating publicity spurred by Lively would have occurred and did occur in the absence of the retaliatory motive. Need another drink, sorry. Now we move on to the Second Amended Complaint lacks factual allegations to directly establish a retaliatory purpose. The Second Amended Complaint includes two cursory allegations of retaliatory intent. One, that the public relations plan was embarked in retaliation for Miss Lively's exercising her legally protected right to speak up about misconduct on the set. Miss Abel, Miss Nathan, number two, Miss Abel, Miss Nathan, Wallace, and Street Relations, and others employed or engaged by TAG, perpetrated a retaliation scheme against Miss Lively in collusion with the Wayfarer parties. This is insufficient to show a retaliatory animus or purpose. In fact, the Second Amended Complaint's own allegations show something entirely different, that the alleged smear campaign was not retaliatory, but an effort to defend Baldoni and Wayfarer against the anticipated storm of negative publicity from Lively and her team's blistering criticism of Baldoni and his work as the film's director to coincide with the film's release. So at the beginning, even when you read the text messages between the Wayfarer parties, you can tell by what they're talking about. They're not talking about anything to do with harassment. They're talking about the fights about the movie and the editing and all of that kind of stuff. I think they were taken aback by the harassment complaints because it was all about like the inside fighting about the movie. That's a good question, Gelf. I want to know how Blake knows there's like 7,000 signal messages, but's complaining she only got 500. Well, Vanzan Sham. She might have seen something. She might have seen something on that ill-gotten stuff. But signal messages, don't they self-delete? So they probably don't exist anymore. I don't know. That's my guess. When she keeps demanding something specific, Jesse. Jesse and Max says, same way she knew there were 50,000 hours of footage. Exactly. She's not good at math. Oh, absolutely. Coco says, I think the Vanzan thing is at the heart of this, and all of this is a distraction. It is. Oh, signal messages don't self-delete. Okay. I thought those were the ones that were disappearing sort of messages. Lisa, good point. This whole thing has just proven to me that the justice system doesn't exist, just the privileged person system. The highest earner wins. It's maddening what they've been able to get away with. It really is. And then the Vanzan attorneys somehow know something about Blake's deposition. Isn't that all sealed? How do they have it? I'm sure they're prepping them with every information they can to get ready for that whole Vanzan Sham deposition. That's going to be the funniest deposition ever taken, because this person that they're sending has no idea, probably didn't even know anything about any of this at the time. Yes, Steve Sarowitz is the highest earner, and boy, does that chap there hide. How many times have they mentioned Steve Sarowitz's money? Boy, does that make them so mad. Lively cites text messages stolen from Jennifer Abel's phone by Stephanie Jones. I love how she just outright says it. She's not mincing words. She's not trying to be careful. She's not alleging anything. She is like, straight up, Stephanie stole this stuff from Jennifer's phone and gave it to Blake to support her retaliation claim. These messages do not evidence a retaliatory purpose. To the contrary, they confirm that beginning in late July 2024, after the completion of production And after the end of Lively's acting services, Baldoni and the other Wayfarer parties consulted public relations and crisis management professionals to plan how to counter an anticipated onslaught of negative publicity by Lively about a feud on the It Ends With Us movie set. I said management earlier, sorry, movie. And the struggle over control of the production, editing, and marketing of the film. It's obvious in those text messages that they think that that's what Blake is still mad about. They had no idea what was coming. Text from Baldoni to Abel that Miss Lively's husband had blocked him on social media stating, "We should have a plan for if she does this when the movie comes out. It would be helpful to arm us in the case we need to refute any of the claims." Abel briefed press on the situation and stated to Wayfarer they were armed and ready to take the story of Blake weaponizing feminism. An August 2nd, 2024 scenario planning document states, "We should be prepared should Miss Lively and her team make her grievances public." Heath stating, "That's the most important part of this is how quickly they can shut things down and play stories in your favor." August 4th, 2024 text from Abel to Nathan regarding reckless thoughts of wanting to plant pieces this week of how horrible Blake is to work with, just to get ahead of it. She's putting us through hell. August 6, 2024 text from Nathan, "This will be for creation of social fan engagement to go back and forth with any negative accounts, helping to change narrative and stay on track." Abel inquiring about the cost of social media mitigation and proactive fan posting to counter the narrative surrounding Baldoni, planning for suppressing of negative content about Mr. Baldoni, and the amplifying of negative content about Miss Lively. That's PR, people. It's not illegal. Defendants' concerns proved prescient, what a fancy word, when on the eve of August 6, 2024 premiere, Lively sidelined Baldoni, instructed cast and crew to defriend him on social media, another thing Blake did, and then wondered why people started talking. She just got mad that they started talking bad about her instead of him. She lined everything up to make him the villain, and it didn't go that way. If it had gone her way, she would have been fine, and refused to be seen or photographed with Baldoni at the premiere, where Baldoni and his family were banished to the basement until Lively finished her pre-show appearances. The public furor, Baldoni's distress over efforts to cancel him, and Wayfarer's goal to flip the narrative and repair Baldoni's reputation that he had every right to do are reflected in the text messages cited in the second amended complaint. Text from Abel that we can't have fans starting to guess why Justin Baldoni is left out of this stuff, helping to change the narrative. Text from Nathan, the worst is over, and that Mr. Baldoni likely would not be canceled. Concerned that over threads beginning to appear on Reddit, speculating about the feud between Miss Lively and Mr. Baldoni in connection with allegations of competing cuts of the film. See, they thought it was about the film. August 10th, 2024, text from Nathan stating that Lively effed herself by doing the unfollow thing and insisting on no photos together. It's been bad decision after bad decision. Referencing August 13th, 2024, text messages that consisted of drafts of a story outlining Miss Lively's role in making final cuts to the film. Baldoni stated on August 15th, 2024 that because of the negative articles, there's no way we can just let this go. Thus, what Lively characterizes as a smear campaign began the week of the premiere and was conceived and executed to counter the onslaught of negative press spawned by Lively and her team, to quell speculation about an alleged rift between Baldoni and his cast and crew, and explain Baldoni's noticeable absence from joint press events and the lack of group photo at the premiere. Plaintiff, in fact, admits that the plan was not conceived to respond to any particular allegation. It was entirely about managing the public perception that Mr. Baldoni feared might follow the theoretical possibility that Miss Lively might decide to unfollow his social media accounts. No reasonable employee should expect that the employer defendant would simply surrender in the face of litigation. Planning to counter potentially negative publicity and efforts to defend one's reputation in the face of highly public criticism is not tantamount to a retaliatory adverse employment action, and plaintiff fails to plausibly plead the requisite causal link either directly or through Baldoni's efforts to manage the fallout from media stories about discord on the film's set and Lively's efforts to sideline Baldoni from the film's production, editing, and marketing. Lively may not like the public criticism she unleashed, but the Second Amendment complaint is devoid of facts that might show that these efforts to neutralize negative publicity had a retaliatory purpose. Absent a sufficient factual basis, the Second Amendment complaint's conclusory allegations of retaliation fail to establish a prima facie showing that the Lively's sexual harassment complaints were the but-for cause of the smear campaign, as required to plead violations of Title VII or FEHA. Plaintiff fails to state cognizable defamation claims. Plaintiff's defamation claims fail under either New York or California law. The Second Amendment complaint fails to state claims for defamation per se and false light under California law. We've already learned New York isn't going to pay any attention to a false light claim anyway. They don't recognize it. They only recognize defamation, which is extremely hard to prove, especially in New York. Defamation requires a publication that is false, defamatory, unprivileged, and has a tendency to injure or cause special damage. The same requirements apply to false light claims. Plaintiff identifies 5 post-litigation statements by the Wayfarer party's lawyer as defamatory per se. Each refutes express allegations in Lively's complaint. Lively was asserting serious and categorically false accusations against Mr. Baldoni, Wayfarer Studios, and its representatives. Lively made false allegations of a smear campaign. Lively's claims are completely false. There was no sexual harassment, and Lively has stated false allegations of sexual harassment. The Second Amendment complaint cynically fails to note the timing of the allegedly defamatory statements. However, since the statements address the allegations in the complaint, there can be no dispute that they were made after Lively filed her claims in the course of litigation. California's litigation privilege, Civil Code 47B, we just talked about this in one of my videos yesterday, where 47.1 clashes with this law that's in the same section of the Civil Code. So, creates an absolute to bar to any defamation claim based on statements made in connection with the judicial proceeding. So anything that Justin said in his proceedings against her, his lawsuit filed against her, is protected by privilege under this litigation privilege because it was part of a judicial proceeding. Section 47B applies to any communication, 1, made in judicial or quasi-judicial proceedings, 2, by litigants or other participants authorized by law, 3, to achieve the objects of the litigation, and 4, that have some connection or logical relation to the action. The privilege is absolute and applies to all publications, irrespective of their maliciousness. And this was in that 47. This was in the 47.1 document that we covered yesterday. Absolute litigation privilege, not limited to statements made during a trial or other proceedings, but may extend to steps taken prior thereto or afterwards. So all of the statements that Justin made in a legal background or a legal setting, he was bringing a lawsuit saying, "You defamed me. I didn't do this," and then brought the claims against her. That is an absolute privilege. She can't come after him for those statements. It protects publications made outside the courtroom and all torts except malicious prosecution. Undergirding the immunity conferred by Section 47B is the broadly applicable policy of assuring litigants the utmost freedom of access to the courts to secure and defend their rights. I recognize these from the 47.1 as well. Yeah, all that, the rest of that paragraph, I think that was all in that document too. So we'll go ahead and move down to B. New York does not recognize a claim for false light based on privacy, and the allegedly defamatory statements are privileged under New York law. So we talked about that in my video about the rest of Blake's claims being no good, that New York will not acknowledge false light, and these statements that he made that she's claiming are defamatory are privileged under New York law. So these will fail as well. New York does not recognize a common law false light invasion of privacy tort. The allegedly defamatory statements are absolutely privileged under New York law. In contrast to California, New York's litigation privilege does not extend to out-of-court statements. However, New York Civil Rights Law 74, Section 74, creates the fair report privilege, which provides absolute immunity from civil liability for defamation. Importantly, Section 74 protects reporting on allegations made in official proceedings, regardless of whether the underlying allegations are true or false. To invoke the Section 74 privilege properly, defendants need not prove that the statements made at the proceeding were themselves accurate. Rather, all that matters for the application of Section 74 is that the article is a substantially accurate rendering of what was said, even if the testimony given was not true. Moreover, there is no obligation for a report to tell all sides of a story to be substantially accurate. Here's where the stuff that got New York Times off the hook turns around to bite Blake. I talked about this a lot. When I first got started with this, the main thing I went after was the New York Times. But in New York, they are protected beyond the Constitution's protections. So these, like this Brady, for example, is another one that they find ways to, proving malice is so hard. And people trying to find ways around it to get it to go through, the New York laws like hold my beer, and they find a way to block that. They are not going to let it come through. So all of these laws that are over there protecting the New York Times protect everybody else as well. So these same things that came up from the New York Times to protect themselves are now coming back and biting Blake in the butt. These statements by counsel, to the extent they can even be construed as defamatory, which they are not. There we go again with the narrator, the Arrested Development narrator. They are not. Merely repeat defendants' assertions made in court and fall within the scope of protected speech under Section 74. Counsel's other statements concerning plaintiff's motives for making her claims are statements of opinion and not subject to a claim of defamation. New York also protects statements of opinion from claims of defamation. New York law grants opinions greater protection from defamation actions than does California law. As we know, New York, they're like, say what you want, we don't care. Print what you want, we don't care. We'll find a way to defend it. When the defendant's statements, read in context, are readily understood as conjecture, hypothesis, or speculation, this signals the reader that what is said is opinion and not fact. Statements of rhetorical hyperbole or imaginative expression are not actionable because they cannot reasonably be interpreted as stating actual facts that could be proved false. And I feel like I'm back when we were reading all this, when the New York Times was defending themselves. And when Ryan, actually, not just the New York Times, these are the same arguments that they used to defend Ryan for this crappy stuff he said about Justin. So here you go. You get it back now. Section 8, plaintiff civil conspiracy claim fails. Civil conspiracy is not an independent tort, and its only purpose is to extend liability beyond the primary wrongdoer to other tortfeasors for all damages ensuing from the wrong, irrespective of whether or not he was a direct actor and regardless of the degree of his activity. To establish a claim of civil conspiracy under either California or New York law, a plaintiff must plead an underlying tort that the alleged conspirators are capable of committing. Tort liability arising from a conspiracy presupposes that the co-conspirator is legally capable of committing the tort, that he or she owes a duty to plaintiff recognized by law and is potentially subject to liability for breach of that duty. A cause of action for civil conspiracy may not arise, however, if the alleged conspirator, though a participant in the agreement underlying the injury, was not personally bound by the duty violated by the wrongdoing. Co-conspirator must be legally capable of committing the underlying tort. A mere conspiracy to commit a tort is never of itself a cause of action. Although, allegations of conspiracy are permitted only to connect the actions of separate defendants with an otherwise actionable tort. This all sounds I'm getting very sleepy now, so I can't make sense of this. A cause of action sounding in civil conspiracy cannot stand alone, but stands or falls with the underlying tort. If a privilege applies to the underlying claims, the privilege extends to obviate a conspiracy to commit the immunized underlying complaints. Let's see. Let me try to find something that... Is Omar here? Hey, Omar. Do you want to join? I'm having trouble with this conspiracy bit, especially. But if you can, I'd love to have your expertise. Oh, you're supposed to be on a date night. Okay. All right. Well, we'll allow it. Happy date night. You're still because... Aw. Well, enjoy your date night. Okay. I'm going to skip over this civil conspiracy bit. It's kind of long, and I'm not... Oh, that's the end of it. Okay. So let me go back and see if I can find... Oh, okay. All right. Thanks, Omar. Yeah, this conspiracy stuff, I think my brain has finally started to go to sleep before my body, and I'm not making sense of the words anymore to get her full point of what she's trying to make. So basically, here, this sounds like it's summing up a little bit. Plaintiff's pleading of a civil conspiracy is less than precise, relying solely on the conclusory allegations that each defendant committed numerous wrongful, unlawful, and tortious acts pursuant to defendant's common plan, design, or agreement. So what she did first is explain how intricate a conspiracy is. In order for it to qualify as a conspiracy, it has to have all those moving parts that she was explaining that my brain just wasn't absorbing. And she's saying that Blake's pleading does not do what it has to do in order to accomplish that. So as her last of all of them, this one is failing too. For instance, as only an employer is liable for FEHA retaliation claims, the non-employer defendants, Baldoni, Heath, Sarwitz, Nathan, Abel, Tag, and Wallace, have no duty not to retaliate, and thus cannot be liable for conspiring to retaliate against Lively. As explained above, plaintiffs' claims under FEHA, Labor Code, Civil Code, and Title VII retaliation claims fail, as do plaintiffs and Title VII retaliation claims. Defendants cannot conspire to commit torts that are not actionable, nor can defendants have conspired to defame Lively as her underlying claims are privileged. The privilege, which immunizes the named defendants, also immunizes alleged co-conspirators. Also, the Second Amended complaint is bereft of any allegation that Abel, Nathan Wallace, and Tagg were involved in the production of the film where the alleged harassment occurred on the set. So she's grouping all of these people as part of a conspiracy, but they didn't all do everything together. Some of the people are accused of doing something on the movie set. Some are accused of having to do with this defamation stuff. So how can you say they're all in on a conspiracy? They didn't all do all of these things together. Therefore, they could not, under any stretch of the imagination, be liable for the harassment or retroactively conspiring to harass Lively. Finally, Civil Code 51.9 applies only to those in a business or professional relationship with Lively. The Second Amended complaint does not allege that Nathan, Abel, Tagg, and Wallace had any duty to Lively arising from a professional relationship, and thus these parties cannot be liable for conspiring to violate Section 51.9. These are only a sampling. I love Ellen. Oh my gosh. She lists all of this and then just goes, these are only a sample. These are only a sampling of the shortcomings in plaintiffs' efforts to plausibly plead civil conspiracy against 10 defendants to commit no fewer than 11 torts and 2 breaches of contract. And then we have the conclusion. For the foregoing reasons, defendants respectfully request that the court enter order granting this motion and dismissing the 2nd through 7th and 12th through 15th causes of action with prejudice. Beautifully done, Ellen. I love you more than ever. Happy Vanzan Sham Day, everybody. And yes, we're going to wear our florals. I didn't get my cookies baked. I really wanted, I don't know if you remember, one time I did a thumbnail and I had a van that was parked outside and it was selling subpoenas. And I was going to try to recreate the van with cookies and call them Van Sham cookies. But I didn't get to do it. So I don't think I'll have time tomorrow, but I am going live with Leanne. I believe Lauren's going to join. I think Ashley might stop by. Hopefully Omar was invited. I don't know who. I think Leanne's putting it all together. And we are going to just get together and celebrate an anti-harvest festival to protest the illegal harvesting of Jennifer Abel's phone. Anyway, Nikki says Ryan is rocking in a corner. I bet he is. I bet he is. All right. I think I made let me find my picture real quick because I was working on I was going to put music and stuff to it. I did put it on there it is. I did put it on X. Vanzan Sham Day. Come celebrate our first ever anti-harvest festival. I think it's going to be 4 Eastern, if I remember correctly. But check with, well, if Leanne hasn't set it up yet, once I see Leanne has set it up, I'll share it from my community tab too. But yeah, check in with Leanne for the exact time. So I guess we need to go to sleep so we can be ready to celebrate, because that's like 13 hours from now. And it's going to take me a while to wind down and quiet my brain. I'll go try my little pulsetto, my vagus nerve thingy, like I told some of you guys about, whoever was here on that chat. I'll go try that, try to get myself to sleep. But Anyway, thank you so much for joining me in the middle of the night. Are we crazy? I mean, how obsessed do we have to be for this? I saw an Ellen document, then I saw what it was, and that was it. There was no going to sleep. So thank you guys for joining and staying with me through it all. And oh, Hen says 14 hours ahead. So if it's 4, it will be 6 a.m. I think it's for Eastern time. Yeah, I think it's like 9 o'clock p.m. Leanne's time. Because originally I was going to be back in Ireland, so we were going to be on the same time zone, but I changed the trip, so I will be home. All right. Have a great night, everyone, and happy Vanzan Sham Day. I'll see you tomorrow.